Hey everyone, and welcome back to The Explainer. Today we're diving into what is probably the absolute most invisible component of any commercial building. We're talking about office floor drains. Now look, I know it doesn't sound very glamorous, but honestly, understanding how to manage this is a massive competitive advantage for any facility operator out there. So if you're managing a property, these grates are basically just silently waiting under your feet. And ignoring them, well, it's kind of like walking past a ticking clock. Consider this for a second. A single, neglected grate that backs up overnight can easily result in tens of thousands of dollars in commercial property damage, and that's before the first employee even unlocks the front doors in the morning. So let's look at why that is.
What might just look like a mundane metal grate on the floor is actually a really high-stakes legal intersection. When these systems fail, whether it's due to neglect or just inadequate maintenance, the consequences aren't just, a little puddle to mop up. We're talking about severe water damage, serious slip and fall incidents, massive disruptions to business operations, and intense, drawn-out disputes over who is ultimately responsible for footing the bill.
All right, so here is our roadmap for today. 1. The hidden legal hazard. 2. Pathways of liability. 3. Defining reasonable maintenance. 4. Key steps for facilities. And finally, number 5. The power of documentation.
Let's start right in with Section 1, the hidden legal hazard.
The first thing we absolutely have to understand is that most of these catastrophic drain failures trace back to entirely preventable conditions. It's usually this slow accumulation that just narrows the drain's capacity over time. Things like hair, grease, sediment, the unglamorous everyday realities of a working building, or even leftover construction debris that's quietly choking the system. Add to that physical issues like defective grates, missing covers, or internal venting and trap problems that allow for terrible odors, or even worse, dangerous backflow. Let me tell you, a slow drain isn't just a minor annoyance, it is a blaring alarm bell.
So when things inevitably do go wrong and a claim gets filed, plaintiffs and insurers aren't just going to look at the water damage. They are going to rigorously evaluate your facility against 3 very specific questions. They'll ask, was the hazard present or foreseeable? Was it discovered and addressed in a reasonable time frame? And, critically, did your maintenance and documentation support a standard of reasonable care?
Moving right along to Section 2, Pathways of Liability. Liability is tricky, you guys. It's definitely not a straight line, and it shifts rapidly depending on the facts. It might become a premises safety issue. Picture a neglected grease trap in a cafeteria that overflows, leading to a really nasty slip and fall lawsuit from a visiting client. Or it could be severe property damage, where a backed-up floor drain slowly destroys a totally mission-critical server room on the floor directly beneath it. Honestly, it frequently turns into these bitter contract disputes between building owners, property managers, and service providers over who is supposed to clean it in the first place. Or it could just be a basic failure of compliance with local plumbing codes. Ultimately, who controlled the area and who did the last plumbing work will heavily dictate who is going to write that check.
Which brings us to the pivot point of our explainer. Section 3. Defining reasonable maintenance.
You really have to fundamentally shift your mindset here. You've got to go from waiting for a flood to actively tracking early warning signs. Reactive maintenance, that is a losing game. Proactive maintenance means you are paying close attention to performance indicators. If a drain is running slow, or if you're getting recurring clogs in the exact same location, or maybe tenants are constantly filing odor complaints, those are the symptoms you have to treat immediately, way before the emergency fix is required.
Now, keep in mind, a practical baseline doesn't mean you're out there tearing up the floorboards every single week. It means routine, scheduled inspections of the accessible components. Are the grates actually secure? Are the seals intact? Are the splash zones, the immediate area where water is meant to flow into the grate, are they completely clear of obstructions? And remember, areas prone to heavy debris, like food service zones or loading corridors, well, they're going to need this preventive baseline applied much more frequently than a low-risk area like a lobby entryway.
All right, let's look at the actual framework. Section 4, Key Steps for Facilities.
The best way to handle this is to start by mapping and classifying the risk of every single drain in your building. Number 1, keep them accessible and unblocked by equipment or storage. Number 2, inspect them regularly for standing water and corrosion. Number 3, when you clean them, do it proactively based on actual usage patterns, not just some random calendar date. Number 4, respond to sluggish drainage at lightning speed, treating any odor as a direct warning. And number 5, of course, meticulously document every single action you take.
And I want to highlight a massive trap that facility teams fall into all the time. A drain can appear to work perfectly at the surface, giving your team this false sense of security while a partial blockage is actually persisting deeper down in the downstream system. So always confirm the flow all the way through after any kind of plumbing intervention. Don't just assume it's fixed.
And finally, Section 5, the power of documentation. When a dispute happens, just doing the work simply isn't enough. You literally must be able to unequivocally prove that you did the work. As this point makes clear, in disputes, records often matter as much as outcomes. Your records, they're your alibi.
Having these specific documents readily available establishes that the building operator actually used reasonable care and acted promptly. You need detailed maintenance logs and inspection checklists. You need the actual cleaning receipts with the service dates right there on them. If an incident does happen, you need the report and a list of the exact parts that were replaced. And critically, capture those internal tenant notifications. Guys, these are often the smoking gun in a liability case because they establish the exact minute management knew about the issue versus when a vendor was actually dispatched to fix it.
Also, for those of you relying on outside contractors, your service scopes absolutely must be explicit. Clear responsibility reduces that terrifying risk of coverage gaps, where literally nobody believes they own a particular maintenance obligation. Exactly which drains are included? How often are they being cleaned? What specific conditions trigger an escalation to building management? Spell all of it out in the contract to eliminate any ambiguity.
So I want to leave you with a bit of a provocative thought today, to challenge how you view the proactive management of your facilities moving forward. If a drain backed up today, like right now, could your maintenance logs prove reasonable care? If disaster struck this afternoon, would your paperwork hold up under that scrutiny? By combining disciplined schedules with rapid response and airtight documentation, you can absolutely ensure a routine floor drain never becomes a costly liability. Thanks so much for joining me for this explainer. Keep learning, and I'll see you next time.